Without further delay, please join me in welcoming the Chief Justice Warren to the lectern.
Good afternoon, everyone. I must express my deep appreciation of the President's very, very warm remarks, particularly the remarks earlier. In fact, I really don't think there's much I can add to what he said. It was so comprehensive, but I'll do what I can. But this is an opportunity for me also at the outset to acknowledge the significance of the relationship between the Law Institute of Victoria and the profession it represents with the Supreme Court of Victoria. During my 10 years as Chief Justice, I have been very, very fortunate and privileged to have been supported when necessary by each of the presidents of the Institute. There has been an enduring and standing relationship that if I had a difficulty with government, needed help with resources or something else, I need only pick up the phone and the President would immediately provide assistance. I do acknowledge that support and assistance, and long may it continue. I thought at the outset this afternoon I might talk a little bit about where we have come from. As I look across the room, I see some very youthful faces who may have not known any other Chief Justice except me. We did have men before me, a lot of them, 10 in fact. And a lot has happened in the last 10 years or so. I joined the Supreme Court when I was 47, that was 15 years ago. At that time, it really was not the forum of choice for most litigators. If you ask the senior commercial litigators in the room, they would agree with that. There was a diminished commercial list, there was a diminished criminal list, the court did murder trials and not much else. There was virtually no common law work. Civil juries had been banished to the county court, and we had a very, very overworked Court of Appeal that was dominated by criminal appeals and also challenges under the then Accident Compensation Act. The court was also under-resourced, did not have enough judges and had limited facilities. So we've moved, I think, to the point where we can say proudly as Victorian litigators and judges that Victoria has come to be one of the best and most preferred forums of choice across the country. The President mentioned earlier the commercial court. It has indeed become the showcase of the Supreme Court. If we reflect on the economic downturn that the nation is experiencing, that is reflected in litigation. And so if we think about what is happening in, for example, New South Wales, their commercial figures are not increasing, and other jurisdictions are having a similar experience. However, in the commercial court, things are very active. In fact, I would say things are jumping. In the criminal jurisdiction, I understand there are not many criminal lawyers in the room this afternoon, but it is a very important jurisdiction. The Supreme Court has shifted from a strict diet of murder trials to also hear very significant Commonwealth trials, terrorist matters, corporate fraud cases and significant large-scale drug cases. In common law, for the common lawyers in the room, there has been a seismic shift. We see a dramatic increase in civil juries. We are running sometimes as many as 17 civil juries a month. And we also see a significant growth in the regions. So, for example, the circuit courts, Shepparton, Mildura and other venues have very, very strong common law lists. Interestingly, in common law, there have been shifts in jurisdiction. It's not just the old sore neck, bad back. There are other cases beyond personal injury. We see a growth in environmental law. We see an increase in judicial review. We also see across the spectrum a growth in the number of class actions. We need only think of the Timbercore, Great Southern, and also the bushfire cases that are underway right now, and also the Wheelerhan case dealing with the Lyndhurst tip. Another development that has happened in the last 10 years has been the implementation of the Human Rights Charter. In Victoria, we are the only state to have a charter. There is a charter in the Australian Capital Territory, but Victoria has played a leadership role in the development of human rights jurisprudence in the nation and is now considered and referred to in judgments across the world where there are bills of rights and that type of legislation in place. It cannot be underestimated the significance of the development of that jurisprudence. It's always good to have a money factor. If we think about ourselves as lawyers, we don't often think about the contribution that litigation makes to the Victorian economy. A little while ago, the Victorian Bar did a body of work, and they've since engaged in further consultation with the Institute. The work that was done estimated that a little under, at that time, $1 billion was contributed annually to the Victorian economy by litigation. Now, that figure will have increased, but you only have to think about your own practices, what flows on from the work, the client coming to see you, the client catching the taxi, the IT that's necessary to support giving the client the advice, the employment of the support staff, the leasing of floor space, the management of documents, and on it goes. We can readily see the contribution that litigation makes to this state. It is an important message to convey to the government. Sometimes it does happen, indeed more often than not, that the role of litigation and the courts will be surpassed and overlooked by more immediate, seemingly, and more pressing demands for hospitals, police, schools, the obvious sorts of political touchpoints. So this afternoon, having given you that introduction, a bit of 10 years quickly, where we'd come from, I'd like to talk about things that we're doing along the way, things we're doing right now. I will then culminate with some remarks about where we're heading to.